for joining today. We are going to go over the Pregnant Workers Fairness Act. As Taylor did say, I am a senior associate in the Federal Labor and Employment Practice Group. I also do New York State Labor and Employment. And I'm going to, reference that this Pregnant Workers Fairness Act, the PWFA, does apply to both private employers and federal employers or state employers. So this isn't just limited to a federal labor and employment issue. Taylor, if we can go to the next slide. So what we'll be discussing today is the PWFA. I'm going to describe what it is, the purpose that it was passed, and what it intends to cover. Who a covered employee is going to be under this law. So beyond just that it applies to every employer that may be at issue here. And then the process for requesting accommodations under the PWFA. There are still other laws, federal laws, that will protect employees in regards to pregnancy discrimination and even accommodations, because when this law did come into effect, there's still applicable other laws that you should be aware of. We can go to the next slide. So the PWFA, it went into effect as of June 27th of this year. So there are still other laws, again, that I spoke to that will apply to a employer's requirement to provide an accommodation, but the PWFA is specific to providing an employee with an accommodation in terms of pregnancy or medical conditions that result because of pregnancy are connected to pregnancy. It encapsulates that specifically where there was a hole in the legal framework before. So this is June 27th onward. If your employer has denied an accommodation related to pregnancy, childbirth, other related medical conditions, and on. So if you made a request, it's an ongoing issue, this law would apply to your circumstances. Anything before June 27th, you would have to seek some sort of support, legal support, before or with another law. This law doesn't replace the other laws that are still in existence. It's supposed to fill in holes or gaps that we've noticed over the years that have come into play. And so that could be, this is beyond just discrimination. It's beyond just asking for temporary accommodations. There's, situations which have been ongoing and persistent for decades now. And through advocacy, this law, the PWFA, is to rectify those loopholes that employers seem to find at times with any type of accommodations that are related to these, pregnancy, childbirth, postpartum depression, fertility treatments, anything that's even remotely related. This law is intended to cover that and for you to be able to seek accommodations specifically for. It does create a cause of action for employees to bring against an employer if it's refused. So if they do not provide you an accommodation, you can file a claim under the PWFA. Specifically, the enforcement or a charge is to be filed with the Equal Employment Opportunity Commission. So similar to, Title VII, ADA, you can bring a charge under the PWFA to the EEOC alleging, that you've been denied an accommodation, you've been denied a job opportunity, you were forced to accept a reasonable accommodation without any discussion on what may be helpful. You can also bring a charge under the PWFA if your employer requires you to take leave and when there might be another secondary, even remotely helpful reasonable accommodation that could be provided to you or is available. So just kind of emphasizing again, as far as when this law went into effect, it was June 27th, which means that, and we'll discuss this a little bit later here, but which means that, if you request an accommodation for pregnancy or childbirth or another medical condition, your employer, to a certain extent, is still required to provide you something if you have, a doctor's note or recommendation in accordance with like the ADA. And they still can't discriminate against you if you are pregnant or any resulting conditions under the ADA or Title VII. But this law is specifically giving you a cause of action as of June 27th onward under the PWFA. So you can allege multiple issues. This is again just for something that's more recent. Taylor, if we can go to the next slide. So what is an employee, or who is covered under the PWFA? The PWFA is for any employer that is over or at least has 15 employees. So most federal agencies are going to be covered. This is just geared towards, what, as far as private or more public companies, entities, they do have to have at least 15 employees to be covered under this. The PWFA, I mentioned there has been existing laws that have provided protections. This is to fill the holes that have come up. This goes a little bit further than just normal requirements under the ADA or the Americans with Disabilities Act, requiring what accommodations an employer must provide an employee. And it goes a little bit further into defining pregnancy, childbirth, what are other related medical conditions than, before what was considered. So I mentioned, this goes from pregnancy to postpartum, covers postpartum depression. It can cover fertility treatments. So this isn't just simply, you are pregnant, you are looking for accommodations during that time period. It's acknowledging that there's things that can happen before and after that are related, in which you might be seeking accommodations to help you or assist you with your current condition. Now, in line that it's expanding the ADA, there are still requirements that an employer has to review and have a discussion with you about what accommodation you're seeking. They do have to process it. They can't just give you one. So I mentioned it gives you a cause of action to bring if they fail to engage in some sort of interactive process. It does adopt, as far as the ADA goes, what exactly this interactive process is to look like. It does understand that, versus a permanent accommodation or some other time length, that it is very specific towards, if you are seeking an accommodation for pregnancy, any complications from childbirth, things leading up to pregnancy, those types of things. It's meant to be temporary. It's an understanding that it's temporary. So it is geared towards individuals where you're seeking a temporary accommodation. It's an analysis that's going to be performed with your input and feedback with your employer. What's an undue hardship on the employer during that time period? So you're not seeking something that's going on for years. It's a very specific analysis that's supposed to be performed on whether or not, any essential function is impacted, how it's impacted. All of those rules will still be employed as what's coming from the ADA. It's just specific towards pregnancy, childbirth, or other related medical conditions. If we can go to the next slide, Taylor. So the other laws that I've mentioned so far that still do apply would be the Title VII of the Civil Rights Act. So this is more focused on discrimination, right? Not providing an accommodation, but it's focused on discrimination. These types of things would be, a current, past, or potential pregnancy if your employer is in any way denying you a job opportunity, an ability to a promotion, a selection to a new position. All of those things would still be covered under Title VII as well. It expands, so the PWFA expands what a connected medical condition may be, but you can still, if your employer does discriminate against you for any of those reasons, for pregnancy, childbirth, potential to become pregnant, still covered under Title VII. It just gives you another legal cause of action. Title VII does include a little bit beyond what the PWFA is. It's more targeted birth control, abortion issue. That is also covered under Title VII. That would be still the proper legal framework for a cause of action if you're discriminated against for your use or your past for abortion or birth control. The Americans with Disabilities Act. Pregnancy was not considered, or still is not considered, a disability. So it expands and says that, so not only just with related or what may be past case law or the EEOC has determined as a related medical condition to pregnancy or complications of pregnancy, the PWFA fills in that gap. So it says that you are entitled to an accommodation for pregnancy. ADA, though, if there's anything related complications, if you've been diagnosed, typically maybe postpartum depression, complications because of going through childbirth, you can still seek an accommodation under the ADA. But again, PWFA is expanding that, so you could potentially have a cause of action under both ADA and PWFA, depending on the medical condition at issue and why you were denied an accommodation. So the Family and Medical Leave Act, FMLA, that is still something separate. You could potentially seek as an accommodation under the PWFA leave if your doctor is recommending that you don't work for a period of time, if you need a different, maybe flexible hours, if you need significant break times. If you need to go out on leave as a result of maybe a complication of your pregnancy or childbirth, you can seek that as an accommodation under the PWFA. However, you'll still have up to 12 weeks under FMLA if you need additional time beyond that, if you're looking for protected medical leave, where as far as those protections there, your employer can't simply, say time's up. If you have a doctor's support for FMLA, you put in leave, it's approved, you can get up to that 12 weeks where it's protected. It's still unpaid in most cases, but it's still protected medical leave. The PUMP Act, Providing Urgent Maternal Protections for Nursing Mothers Act, is something also separate. For a year following the birth of a child, agencies and employers, so going back, this is both public and private into the federal sector, agencies and employers are required to give employees suitable break times so that if you need to, pump breast milk or something like that, there's supposed to be procedures, policies in place by your employer on how that's to be handled. That's something separate from the PWFA. So that should be a accommodation that your employer has already put into practice. That has been in existence for longer than the June 27th that I'm saying that the PWFA has come into act. If we can go to the next slide, please, Sailor. So how to request accommodations under the PWFA. First, you do have to establish that you're an employee who's qualified under the PWFA. Mostly, this is if you are pregnant, if you just had a child, if you've had some sort of medical condition resulting from either one. This is just as what maybe you've already experienced with the ADA. You're requesting and you're providing a doctor's note. That's just maybe something where your doctor says, you are pregnant, you just experienced childbirth, you've been diagnosed with X as a result of childbirth, whatever the case may be, similar to here where you're demonstrating that you do have a medical condition, what it is, and then making the specific request. You should follow whatever procedure your employer has set up. So that may be a specifically designated individual you're making a request to. There may be a form maybe that your employer has created. It should be just simple, and it should be asking specific information as to what requested accommodation you're looking for, and other information on, how long is this going to be in effect? What is your doctor recommending? Things of that nature. But I would recommend, if your employer has they may have something already set up for requesting accommodations. Given it's been about a month that this has been in effect, but employers have been knowing that it's going to be coming in since I think December of 2022 when the president signed it. They should have been starting to formulate or be specific on if there's going to be any difference in following those procedures for the PWFA specific accommodations. Now your accommodation request does need to still be reasonable, and that's been something that has been defined, and that's going into an undue burden or hardship on an employer to carry it out. Now your employer, it's their burden to demonstrate why it's an undue hardship to give you an accommodation requested. Accommodations that you can seek under the act could be periods of time where you're able to sit. A stool, if you're standing, if you're greeting people as they come through the door, if there's a specific maybe chair that you may need, some sort of support, those types of things can fall under the PWFA. A closer parking spot, so instead of being forced to walk for significant lengths, you're maybe able to get a closer designated parking spot for a period of time. Flexible working hours, start and stop times, different than your normal schedule. If you wear a uniform, if you have safety apparel, this can fall under a reasonable accommodation request as well. If you're supposed to be wearing a certain type of coat, something that would obviously be affected in, a change in size with pregnancy, those types of things, different clothing maybe that you have to wear, that maybe is outside of the normal uniform. Break times, if you need to take significant breaks, if you need to take smaller breaks throughout the day, those types of things can be possible accommodations. And then also, if you're required as part of your duties, strenuous activities, heavy lifting, lifting over your head, carrying things for certain durations, those types of things, climbing stairs, those types of things can be sought as accommodations as well. Now, it does have to be related in terms of the accommodation. It does have to be related, and you do have to have your doctor recommend some sort of accommodations that are going to help you in the performance of your duties. Now, this is temporary. Obviously nobody's pregnant for longer than 9 months. So these are accommodations geared towards whatever length of time from when your doctor recommends it to maybe when the specific medical condition, pregnancy, childbirth, whatever may be related to that is going to end. So the agency should not, or your company should not be evaluating it in terms of, this is going to be a burden on the company for a long time. Just very specific, how can someone, assist with those types of tasks if they're, essential that need to be performed every day, something of those nature. You can address on the front end when you're making your request whether the accommodations are reasonable. You can justify the accommodations where it doesn't really give your employer ability to push back. If you're explaining or you've taken into account that someone else maybe has to do this duty for a certain period of time. If you're able to perform a function in another way, if you're able to do it during a different time frame, things like that, you can already account for that and you can explain it in your initial request. Now this might not always be something that you're able to figure out, but if there has been previous employees who have been pregnant, who have had any type of medical conditions, complications from pregnancy, from childbirth. You can look to see what they have granted in the past. You can look to see what other, maybe if someone else had a different medical condition and say they weren't able to lift 50 pounds, what other types of accommodations have been given to that individual. And you can make recommendations on what may help you or assist you. Don't always let your employer fill in the blanks, right? Now, you can consult with others in your employer's office. You can consult with human resources. If you have a specific EEO office or the discrimination accommodation office, they may have different specific designated employees in the office that handle the various matters, but you can ask them and you can ask them to assist you. You don't have to just do this alone, or seek a private attorney to assist you with it as well. Undue hardship is something that you do hear a lot, and I'm, saying you can be proactive and explain to your employer, that it's not going to be, or what can be done in the meantime. But undue hardship has to be something that's, it creates a significant difficulty or expense for your employer. It just coming back and saying, it's going to cost us, $10 for whatever you're at, a stool. It's not going to be something that's a significant difficulty necessarily for your employer. So they're looking for, is this going to, how is this going to affect the employer's ability to carry out, their mission? Is it going to cause significant delays? Is it going to cost an extreme amount of money? Do they have to have someone, take over your duties for every single day? Are you not able to do anything? But then it's the analysis of, is there a possible reassignment? Is there an alternative that can be done? And now keep in mind that PWFA creates a cause of action where they can't require you to take leave if there's a secondary accommodation that's available. That could include reassignment. Now, these are temporary accommodations, so that's a temporary reassignment. It allows you to continue working. It ensures that, the essential functions of your previous position are conducted, but it's not depriving you of a job opportunity. It's not taking you out of work when you're otherwise able to work. So I went through some possible reasonable accommodations that could be covered under PWFA. And just to emphasize again, this could be also additional leave time that you can request if you need to, following childbirth or other complications that may come about, than just simply requesting FMLA. If your accommodation is denied, or if any of those other issues I mentioned come up, you have to accept a reasonable accommodation without any input or feedback, any discussion as to what accommodation should be provided. If they require you to take leave, significant amount of leave, when there's a secondary viable accommodation that could be provided, a reassignment that's possible. If they deny you job opportunities because you requested an accommodation under PWFA, anything of that, or they deny your accommodation, you can bring a cause of action under PWFA. It is to the EOC, as I mentioned, and I would definitely seek counsel to discuss what maybe the best options for you moving forward would be. And I would recommend doing it, within a few days of the denial being received, just so that if there's something that can be done immediately, an attorney could help you address that as soon as possible, because we are talking about something that is more an immediate accommodation that does need to be provided. If we can go to the next slide, please, Taylor. Now, if you are denied an accommodation under the PWFA, I would still recommend, seeking advice from an attorney if possible. But I would also contact your EEO, your local EEO counselor, Equal Employment Opportunity Counselor, HR, to advise on who you're supposed to be in contact or filing a possible complaint for a denied accommodation. They should have that information to you, and they should give it to you regularly. That's a requirement that's been in existence for a lot longer than just the PWFA. So if at any point they're giving you the runaround or they don't know who is supposed to be the designated individual, it should be someone who has been providing or assisting with accommodations for medical reasons to date. That person at the very least should be able to help you and point you in the right direction. What I would recommend, and I've done this in other instances, if we're filing for just, accommodations under ADA, I would go back to your employer immediately and say, what else can be provided to assist in giving me an accommodation? What else can be provided for my doctor? What else can I do to help? What additionally would be needed for the company, the employer, to provide you what you're seeking? Don't just leave a denial as a denial and not follow up. Because it's possible, there's something else that maybe there's something that can be provided from you, something simple even that can be provided from your doctor. And then I would, consider if it's not an outright denial, did they give you an alternative? Did they give you something in consideration of what you are asking for? What is that secondary alternative option? Is it viable? Is it something that could help you, or could it be modified? Is there something that it can be tweaked with to give you just as much of an accommodation as what maybe you were looking for originally? Now, if you are denied an accommodation, it is a 45-day deadline to contact a counselor to file a charge. I would still, 45 days can be a long time, that's a month and a half. I would still try to rectify or deal with all of these things immediately as they happen. It's not that you're going to miss a deadline, but it is something, it's an immediate concern for you. It's not something that you're looking to possibly not have resolved for a month and a half. So the faster that you can contact someone, the faster you can deal with, the faster you can talk to your company, your agency about the denied accommodation, alternative accommodations, the better it is going to be for you and your health. If we can go to the next slide. So what an attorney could do for you, things that I often do on behalf of clients, is that we're, identifying exactly what happened. We're preparing the actual complaint that you might file. We're interacting or negotiating with your employer on your behalf. We might be, I guess, a middleman to some extent, but we're taking away that difficult, stressful interaction that may happen between you and an HR or an EEO counselor or supervisor, and we're inserting where you're no longer having to be forced to have those interactions. There's someone who's advocating on your behalf. Now, some people are perfectly able to, interact with their employer and advocate for themselves. And, an attorney, though, is just meant to assist in that difficult time, in that situation, so that, you're not adding stress to an already very stressful situation. What I've also done is drafting the complaint. So if, you might say, give a timeline of things that have happened, the interactions with your employer, I may be able to pull out things that you're not necessarily thinking are violations, but could very well be. And putting that in a framework in which it's going to be easy to understand exactly what the agency or your company did wrong, and putting that forward for them to have to deal with. The thing that I can say is, when you do have counsel involved, that may have your company or your agency's counsel become involved. And at that point, we're removing their middlemen of the HR and the supervisors. We're going right to counsel, and it's able to kind of hash out exactly what the requirements under the law are that we all understand it to be, and what can be done to hopefully rectify the issues that we can find. Having counsel, obviously you're not having to then think about timelines and, what documents need to be filed and put towards the agency, the company. Those types of things are tracked by someone else. And you know that someone else is taking care of that for you, that will follow up with you on what's needed. But you still have, an impact and input into what's going on, what's being said, interactions with your doctor. So that the aspects that you still have control without being forced to manage every little thing that might be going on in the request for accommodation, or if you're at that point where you're filing a potential complaint and you're proceeding with a charge and a lawsuit before the EEOC. And I think that leads us to the end here of the slides and questions. So there were a few questions that were sent beforehand. I'm just going to, I believe most of them were addressed.
If anybody has any additional questions, please submit them in the chat and I will send them over to Amanda to answer.
So if people wanted to start sending additional questions, I do have a couple from before. Some individuals or someone asked how managers could be proactive in the process of requesting accommodation. It's possible for your employer to agree to do some sort of accommodation in the interim. So I know we've been talking a lot about temporary, these are temporary accommodations. It's possible they might grant you something in the interim while you're engaging in that interactive back and forth discussion on what kind of more of a permanent temporary accommodation could be provided. So if you're asking for 100% telework or 100% remote work, can that be provided in the next couple days while we figure out if that's a possible accommodation that could be provided on a more regular basis for this foreseeable future. Proactive managers could be in regular communication with you, not just waiting for you to come to them, and seeing and talking with you about what are you talking with your employee about what may be a possible accommodation, not just putting all of that on your employer or employee to provide to you. Accommodation requests, again, they could be denied if your employer can show that there's an undue hardship or burden to giving you that accommodation. And they can't just stop there. They should provide some sort of explanation on why they cannot provide it. And they shouldn't just stop there and saying that it's just denied. There should be some alternative that is recommended, or they should be working with you and saying, we can't give you this, but would this help as well? And then there should be some interaction between you, your employer, and maybe your doctor on if that would resolve the concerns or what the original accommodation was being sought for to address. Let me see. So we had a couple other questions. How are employee numbers counted, and do part-time employees count in the total to reach? They should be. An employee should be anybody who is, I guess, working for the company. So if they have, obviously if they have 10 employees in total, which would probably include, your supervisor, anybody who is getting a salary from the company. It should be anyone who is an employee of the company who is performing services. That goes to the total of the 15. Are there any requirements for length of time worked for an employer? There should not be. This should be if you are an employee for 15 days and you find out you're, pregnant, or you are, needing an accommodation for the foreseeable future because of related medical conditions, that should still apply for you. It's an accommodation that you should still be able to seek under the PWFA. Would it be considered a reasonable accommodation to be moved to another position in the company temporarily? It could be a possible accommodation. You should, and a follow-up question, would the pregnant employee be able to refuse the temporary assignment? You should be engaging in the interactive part. They should be asking you, what accommodation you need. Does that include a possible reassignment? And if it cannot be provided in your current role, there should be some discussion that occurs between you and your employer on what that maybe temporary reassignment looks like, what's available to you. Bigger the company, bigger the employer, more opportunities for a possible reassignment. Obviously, if we're talking about an employer who's 15 employees, That's going to be much different on what other roles that you might be able to perform or whatever they can offer you than, say, the federal government. You know, there might be something, a grander scale that they can be looking at and options that may be available to you on that temporary basis.